before your lordships, which I will then wonder. If I may just state those for your lordship's benefit. Now, the first three submissions are basically about right of hearing and non-parties. His first submission was that the party which has been granted relief, which is PTI, was not a party. So how can a non-party be granted relief? Whether 187, the power under Article 187 can grant relief to a non-party, that would be a central question. 10 at least judges have decided that yes, relief can be granted to a non-party. One of the learned judges, the Honorable Chief Justice now, said that the matter is to be remanded.
On what reasons? On what reasons?
I'll explain. Zara sa main aapko overview de दूं. तो पहला objection है. The second objection which has been raised, and I'll read it precisely because frankly I didn't understand this objection. The parties who had been denied as a consequence of general election a portion of reserved seats were not before the court. There is no such party जिसको reserve seats मिलनी चाहिए थी, who was not before the court, because all political parties are parties to the appeal. So I don't really understand, but maybe wisdom will come to me. Roman 3.
Which party was respondent? PTI was also party.
जी
नहीं, आपने कहा है जो objection.
The parties नहीं, ये objection ये है कि जिनको deny की है वो कोर्ट के सामने नहीं थे पार्टीज, तो वो सारी पार्टीज तो थी जिनको डिनाई की है, PMLN, PPP, JUI, MQM, वो सब कोर्ट के सामने, शुरू से कोर्ट के सामने. The third objection.
But PTI was not party.
No, this is about denial, sir. ठीक है?
ठीक है.
Third objection. The parties in favor of whom the notification of ECP was struck down were not before the court. It's not clear whether he's saying all parties were not before the court or some of the candidates were before because a lot of the candidates were before the court. And it is irrelevant because those candidates were represented by their political parties. They, from the very beginning, from the ECP, those candidates जिनको reserve seats मिली थी, उनको तो उनकी political parties ने दी थी. वो political parties सारी की सारी सामने थी. Number 4. These matters were not a matter of record before the Honorable Court. What was not a matter of record, one fails to understand. Number 5. Now this is a substantial objection. The timelines provided by the majority judgment were beyond the Constitution. This is a point also made by His Lordship Justice Mandokhel in his dissent. That is where he dissents. Partly, even on that, he partly dissents. Roman 6. It was on the basis of these submissions, Article 225, Article 175, Sub-Article 5, and Article 1B, Roman 2 were not even referred in the majority judgment. So passing a judgment which moves away from any of these constitutional provisions and allocates these lists on the basis of doctrine or fidelity, which doesn't have mooring either in the constitution or jurisprudence of this court, were not warranted. A new point was raised on which your Lordship Justice Mazhar questioned that the petition before the Peshawar High Court, it was argued, was not maintainable because of the bar under Article 225. An objection which has never been raised before the Peshawar High Court.
This objection was raised yesterday by Mr. Makhdoom.
Yes, unki objections mein kar raha hu. Now, there is a very simple answer to it, which I'll give, but let me just state that this is an objection which is for the first time being raised. As far as the objection that it is violative of Article 175, Sub-Article 2, that is a point which His Lordship Justice Aminuddin in his judgment has relied upon. And that is where I think it's taken from. Then the seventh objection, which has been taken for review, is that Article 187 did not give this Honorable Court any jurisdiction in the matter. It allowed this Honorable Court to dispose of a case in which jurisdiction was validly invoked by molding relief. Now, basically, the argument here is that 185 does not create a jurisdiction. It creates a power. And that power can never be extended. Now I'm talking about this case. That power can never be exercised by granting relief to a party which is not a party to the proceedings. That is the argument which was put forward. So these are the 7 objections which have been raised regarding seeking review of this judgment. Now, my lord.